Number 2, Marin versus Constitutional Realty, Menkes, Golomb.
Good afternoon, Your Honors. May it please the Court, my name is Scott Horn, counsel representing the appellant Cheryl Menkes in this matter. If I may, I'd like to reserve 3 minutes rebuttal time.
Yes, you may, sir. 3 minutes, you said?
3 minutes, Your Honor.
Yes.
Thank you. Appellant contends, Your Honors, that the lower courts erred in awarding Respondent Golomb 40% of the net attorney's fees in this case, and likewise erred in awarding 20% to the Respondent Mannheimer. With regard to Golomb in particular, the agreement in question unambiguously entitles him to receive a 12% fee for having handled the mediation of the matter. We submit, Your Honors, that the tipping point between the 12% fee for handling the mediation and the 40% fee for assuming the far greater responsibility of trial counsel was whether the, quote, mediation, unquote, resolved the case. Here, it's uncontroverted that after having brought the parties from $18 million apart to $1 million apart.
Counsel, what if the mediation were over not just 2 weeks, but there was a trial date set, and just before the jury is selected, after talking to the judge again or someone else, the case settles? Would that be the result of mediation, or would that be something else?
I think that I missed the beginning of your hypothetical. When you said the judge, do you mean that the mediating judge or the trial judge was negotiating between the parties at that juncture? So if it's the mediating judge, I think that's a dispositive distinction.
Even if they're already in court?
That's correct, Your Honor. I think that when we talk about the mediation, we're talking about the mediator negotiating, bringing the parties together, bridging the gap. At the end of the session, the gap was narrowed from $18 million down to $1 million or perhaps $1.5 million, depending upon whose story you believe. And then he specifically contemplated continuing the negotiations. One of the more salient
So if what matters is that the judicial mediator is involved, or that it's part of this process that's a mediation, why is the date included in the agreement? Why does that matter?
Well, I would submit it doesn't matter, Your Honor, quite frankly. I think that under the case law that we submitted, the Gravitt case from the Southern District, the NCS case from the D.C. Circuit, and the Massachusetts Mutual case from the District Court of Massachusetts, it clearly establishes that the manner in which this language was inserted by Golomb into the agreement merely makes it a clause of description rather than a clause of limitation.
But even if we assume that, let's assume that's correct, and that was the dissent's point too. You have the phrases of the contract itself referring to the mediation rather than mediation, which is a process. That's an arguable point. It's a difficult distinction maybe, but it's certainly, I would consider it from your point of view, a drafting error. But further on, the language says then, quote, whenever the case is resolved, entitled to 40% whenever the case is resolved, whether by settlement, verdict, or trial. Settlement seems to be a difficult distinction for you to be able to draw here on your side of the case.
In other words,
they settled the case.
They settled the case via the
Right.
mediator. That is correct.
Right.
And as a consequence,
Whenever the case, entitled to 40% whenever the case is resolved, whether by settlement, comma, verdict, or trial.
well,
Am I
that
misreading
starts
that?
out by saying, in the event the matter has to be tried. Is that the sentence that we're reading from at the bottom, the last full sentence of
The
the
sentence
second
before
pertinent
that.
paragraph?
No, it's the sentence before that.
Okay, this percentage, the sentence before it, okay.
Yeah, let me go to my notes here.
It's
Yeah.
the second sentence of that
I've got-
paragraph. You're reading the third.
Yeah.
Judge Fahy is
After
referring to
such
the second.
mediation, I will be entitled to 40% of all attorney's fees whenever the case is resolved, whether by settlement, verdict, or trial, or appeal, calculated afterwards.
Okay,
right.
yes. So after such mediation, meaning that the mediation has ended.
How do you know when the mediation ends? Here, there was a 5-hour mediation. They received a bill for the 5 hours. The mediator said, I'll keep in touch with you, but the attorney had to pursue the mediator several times, and I haven't gotten to it, whatever. And there was a lot of negotiation about the details of the settlement after the mediator was completely out of it.
Well,
So And just in answering that, I just want to throw one other thing in there. There's the first sentence of the second paragraph referring to the 12% fee says, for those services, that is mediation, 12% whenever the case is resolved, whether by settlement, verdict, after trial, or appeal. So how does verdict after trial come into that? That's saying 12%, even if there's a verdict after trial. So obviously, if there's a verdict after trial, the mediation didn't resolve it. There was a trial, and the second paragraph says you get 40%. So how do you?
Well, again, the drafter of that language was Golomb. My client didn't draft that language, and you can look at the various iterations and drafts at pages 969 of the record through 972, which is very important in dealing with some of the arguments that the respondent's
But your client was very careful. I mean, she made sure to add that last sentence so that no matter what, he wouldn't get 12 plus 40,
Plus 40,
right?
that's correct.
So
That's the only sentence that was added as a consequence of something that she voiced in the context of those emails.
I guess what I'm getting at is, as I read this agreement as a whole, there's a lot of confusing language, and to me, there's a lot of ambiguity.
Okay,
So
fair
why,
enough.
how can we say that there's no ambiguity here if none of us and none of you can agree on what it means?
Well, fair point.
And we have reasonable points of view.
Both the majority and the dissenting opinion in the appellate division found it was unambiguous. We maintain it was unambiguous and is unambiguous. In the alternative, if it is ambiguous, this language should be construed against the drafter. And that's why these drafts, these various iterations, come into importance. Pages 969 through 972 of the record. Page 969 is the original draft, which Golomb admits at page 48 of the record that he drafted. And what's important about that is that the language that Your Honor is struggling with and the language that you find that may be ambiguous must be construed against the drafter. So that's an alternative argument. And if that's the direction the court's going, we would respectfully submit that in construing this language, it should be construed in accordance with the interpretation that's being offered by Ms. Menkes, which is 12%.
Or should the trial court go back and look at this extrinsic evidence and discern the intent of the parties?
Well, that of course becomes part and part of it, right? When there's a ambiguity, then we can start looking at extrinsic evidence, which is again why I refer the court back to these drafts, right? We couldn't consider these drafts really unless there's some sort of ambiguity within the four corners of the document that was executed by the parties. So that would be part and parcel of the analysis, as well as things like the expert affirmation that was submitted by Ms. Menkes regarding what mediation is all about, and specifically about how this mediator, after the 5 hours was over, after having bridged $17 million out of the $18 million gap, it specifically contemplated, the last point that I'll make is a very salient piece of evidence at page 1048 in the record. This is the Boole affirmation. This is the other party in the negotiations. He submitted an affirmation, which would be extrinsic evidence, which specifically said, I understood that the JAMS mediator would be continuing his efforts to bridge the gap in the ensuing days. And he further says, it was my understanding that Mr. Herkin-Torres would be in contact with the attorneys to continue the negotiations. That's precisely what happened. The offer was ultimately related to the mediator by the defendants. The mediator took it to the plaintiff. The plaintiff accepted to the mediator. That sort of shuttle diplomacy is the quintessential mechanism of a successful mediation.
Thank you, Mr. Horn.
Thank you.
Counsel?
May it please the court, my name is Brian Shute. I represent Mr. Golomb here. Our position is very simple, ultimately, and that is construction of a contract begins and ends unless there's an ambiguity with the plain language of the contract.
What if this case settled an hour after midnight on the day that they actually met face-to-face? Same result?
Judge, actually, I addressed that very hypothetical in my brief. If it settled at 12:01 or 4:01 in the morning, if they continued, And I said if that was the same arbitration that began on the day forward, then it's part of the arbitration. But our point, part of the arbitration...
What if they broke at 7 o'clock and they all went home? And the mediator wakes up in the middle of the night and he has this brilliant suggestion for how to settle the case, or, you know, and at 12:01 he starts making some phone calls and they all agree. What then?
Your Honor, as I also indicate in the brief, there will come a point that you give me a hypothetical and I'll say, you know, that's very close. If the facts were more like Ms. Menkes actually alleged them to be, that the arbitrator had a cold, and it was truncated because the arbitrator had a cold, and everyone agreed that it was going to settle. We all knew it was going to settle when we walked out of the arbitration, and it was adjourned to the next day. Well, those would be obviously a completely different set of facts. They're not the facts, however, of this instance.
So, counsel, what settled this case?
It may well have settled as a result of the mediation, although we'll never know whether it wouldn't have also settled at the same exact sum had the case gone to trial. We'll never know that. But the point is, Your Honor, that the contract did not say that Menkes would receive the higher fee if the mediation process resulted in the settlement, or if, quoting from page 5 of their brief to this court, Golomb, quote, assumed the significantly greater obligations of trial counsel. Nor did it say that there was a trial counsel fee and a mediation counsel fee. All those terms were invented for the purposes of this court. What it said was there was a single bright line distinction. Whether the case did or did not, quote, resolve at the mediation, comma, presently scheduled for May 20,
Presently
2000.
scheduled.
Presently scheduled.
What's the import of that word?
The mediation date could have changed, Your Honor. It was presently scheduled for that date. It could have changed to May 30th. It
Aren't
didn't,
you asking
but it
us,
could
though,
have.
If we promulgate your rule, Mr. Shute, then we will be saying the word "the" would be enough to, we will be promulgating, in essence, an otherworldly rule, in my experience, in mediations and arbitrations, both as a judge and an attorney, because they always go over the set amount of time. People have to contact other people. Sometimes there isn't a formal adjournment, but just say, well, we'll talk later. I'll get a phone call later. Somebody called me back. An adjuster called back and they got some more money. And 2 days later, in this case, I guess 13 days later, the case was finally settled. The rule that you're promulgating basically says that based on the distinction between the mediation and mediation is sufficient to enable that process to be limited to the specific scheduled period, when in point of fact, experience usually is that it isn't quite so contained.
I beg to differ with Your Honor, both as that being my claim
I figured you would.
and that
Okay.
distinction
Yeah.
exists.
Yeah.
It's not the distinction so-called between the mediation and mediation.
Mm-hmm.
At the mediation, presently scheduled for May 20th, 2013, at the mediation. Now, if we had the alternative, Your Honor, if it's scheduled as a result of mediation, if it's settled, rather, as a result of mediation, the argument then could be made at trial, on appeal, any time in the case, that the groundwork was laid during the mediation and that it settled as a result of the mediation, no matter what happened at trial. And indeed, that argument would certainly be made in this case, where even with respect to hard facts, what was the last offer? What was the last demand?
What about the structured aspect of this? Because, you know, I wonder whether if at the mediation on May 20th, they agreed on the number, and everybody agrees that there needed to be some further discussions about how it was going to be structured and what the insurance company was going to be and all of that. Would that then, in your view, also take it beyond at the mediation?
Again, Your Honor, I can't answer that. It would be much closer, and it would depend upon whether you construe it as the number being sufficient. In this case, there was no agreement as to number. There's an affirmed finding of fact that the parties left without any agreement at all on anything. With the appellate division ruled We are not here concerned with mediation, the abstract of what Menkes claims it meant, that when they left, there was nothing. Nothing was settled even in principle. Justice Edmead said that, and the appellate division
But the
majority
mediator
said that.
continues to act, to reach an agreement.
The-
I mean, what's the point of that?
I'm sorry, what's the point
What's
of
the
what?
point of the mediator's continued involvement?
The-
Whether out of
Something
gratuity,
might
out
happen.
of niceness?
No. Something might happen or not happen. But the point is, the arbitration, whatever happened at that point, after that point, was not going to happen at the arbitration presently scheduled. And the parties could have had a subjective qualifier, in which would have been very difficult to enforce and to
Let me
interpret.
ask you about the paragraph. If the case does not resolve at the mediation presently scheduled, that paragraph, why isn't that paragraph, or that sentence, let me put it this way, that sentence less about the date of the mediation and more about what the attorney's responsibilities are post the failed mediation?
Well, I agree.
Why isn't that sentence about, okay, this is what I'm doing afterwards, I'm prepping for trial, and the rest of the paragraph is clarifying the fee associated with that trial prep and potentially going to trial?
Your Honor, I agree that the date is identifying the arbitration. If you took out the date and you said at the mediation, I keep on saying arbitration, I'm sorry, at the mediation, it wouldn't be materially changed, but they mean at the mediation. It means at the mediation.
No, you're misunderstanding my question. Perhaps I didn't make it clear. What I'm saying is you're focused on the first part of the sentence, understandably so, because it's the first part of the sentence. But after the comma, after the date, is really what this sentence is about, is it not? What this lawyer's responsibilities are post-mediation. Because the paragraph before this is about responsibilities related to the mediation and the fee. But this paragraph is about, okay, we don't solve this at mediation. Does this attorney's responsibilities to this case end or not? And that's what this paragraph is focused on.
And I think, Your Honor, you have to look at the sentence afterwards that Judge Fahey was reading before, and that, contrary to what Mr. Horn said, was in fact drafted by Ms.
I know, it
Menkes.
says you get 40%, or your client gets 40%.
The sentence before, the version at 969, which was the initial version of it, it provided, bear with me for one moment. Once such preparations commence, it immediately follows the sentence that you asked about, Judge. This is the sentence Judge Fahey mentioned. Once such preparations commence, I, meaning Golomb, will be entitled to 40% of the gross attorney's fees whenever the case is resolved, whether by settlement, verdict, after trial, or appeal. That was changed, Your Honor. It was changed at Menkes' behest, and it was changed because he was going to begin trial preparation, had to begin trial preparation before the projected date of the mediation. The trial was going to follow immediately after the mediation.
But what you're referring to as trial prep is in furtherance of mediation. It can also be used for trial prep, agreed.
Yes, but at this point, as Mr. Golomb noted
Make it
at
seem
page...
like your client was doing two things, separately and independently, preparing for mediation and preparing for trial. When that's
As
not what's
Mr.
going on.
Golomb noted at page 933 of the record, the kind of preparation that one would do for mediation is not the kind of preparation that one would do for a trial, because the trial was expected...
And there's no overlap? There's nothing
Oh,
that
sure there's
benefits
overlap.
the effort
But-
at mediation?
Sure there's overlap. But in terms of the quantum of work, it's not the same degree of difficulty. And they anticipated that indeed he would be doing trial prep. And this is why that sentence was changed at Ms. Menkes' behest to where it currently is in the agreement at page 970, the sentence that Judge Fahey read, after such mediation, referring to the prior sentence, the mediation that's presently scheduled for May 20th. Your Honor, I know I'm over time, but...
But isn't the point of the sentence after, well, a couple of sentences down, in the event this matter has to be tried, right, there you're clarifying, it's the 40%. If it has to be tried, it's the 40%. Are you saying there's
no,
some limbo
that's-
between it has to be tried and it doesn't have to be tried?
In the event it has to be tried, that sentence goes on to say that both Golomb is responsible for trying it and Menkes is responsible for helping him try it. Both things are mentioned in that
But
sentence,
yes,
Your
but
Honor.
the focus
But
is
it doesn't
about the
relate to the
40%.
triggering of the fee.
Right, but the sentence is focused on clarifying it's the 40%, right? That is 40% for that and mediation.
The
If it has to
triggering-
be tried, your client gets 40% for that, any work related to that, and the mediation. Isn't that
The
the point of that
triggering sentence is the one that you asked me about before. The triggering sentence is the one at 969, it's the one that you read before, that ends presently scheduled for. If I may, Your Honor, this is
Last point.
a point that was made in their reply brief, and therefore I've had no opportunity to address. The claim made in reply, and why the argument that we're now talking about is preserved for appeal, supposedly, is that it was made in a brief dated October 1, 2013, that it's not in the record, but the appellant exhorts you to consult as where they actually made this argument, supposedly. However, when you look at that memorandum, which is not in the record, what you will find is the argument there made, the two sentences that were quoted, it's page 8 of the memorandum, are the two sentences we've been talking about. The argument made in the memorandum is not that those words literally mean what appellant now says they mean. The argument there made was that courts have the authority to reject, quote, a literal reading of the contract where it defeats the purpose of the agreements, that quote, little interpretation would effect an absurd result, and such would also provide Golomb with a, quote, unconscionable incentive to delay. And my point, which is point 1 in the brief to this court, is that everything that you've just heard today in oral argument, and most of what you've read in their brief, was not in the lower court, or even in their main appellate division brief, but surfaced in their reply brief in the appellate division. Thank you.
Thank you, sir. Counsel?
Yes, Your Honor.
Counsel, hold on one second. Counsel?
Oh, I'm sorry.
Anxious.
May it please the Court, my name is Jay Breakstone. I represent the estate of Jeffrey Mannheimer. I feel like the odd child out. Everybody wants to get at everybody else, and without saying it in sort of sub silencio, I can't figure out what I'm doing here. So with the Court's permission, I'd like to address the point I made with reference to 5601, because that's the mechanism by which I came here. We've always understood, and I am just as guilty, understanding that a dissent brings up a two-person dissent brings up all issues. And that is a great rule for most cases. It's not for this case. It's wrong in this case, because not a single judge, be it in the Supreme Court or in the appellate division, has ever agreed with appellant, has ever disagreed
So
with
there should be a different, you're
respondent.
saying there should be we've never said that there is a different rule under the circumstances you're describing. You're saying that we should make that a
I'm
new
saying
rule?
this would be a good opportunity to write on the subject. Let's put it that way, because here it's unfair. It's unfair to this widow who had to pay to prosecute this appeal, which was completely unnecessary. And the Court does have a mechanism available to it, and it used it in a bunch of cases involving condemnation proceedings in the 40s and 50s. Having to do with the Harlem River Drive and I think the Bronx-Whitestone Bridge. Because there were multiple claims made against the same owner. And the Court said that the 5601 rule that we all think we know what it means, the essence of that rule is practicality. And sometimes, rarely, not in every case, sometimes that practicality standard gets offended by cases just like this one, in which the only commonality between Jeffrey Mannheimer and this fee dispute between Menkes and Golomb is that at some point in time, the fee will come out of the same pocket, which is to say Menkes. Other than that, the cases are completely unrelated. They don't-
Can I ask you just a
Sure.
little bit on the merits? Because it's not clear to me that we have ever spoken definitively about this situation in terms of when there's a violation of the fee-splitting rules, whether there may be, in any event, an enforcement of the contract, and if so, when? Would you speak to that for a moment?
Absolutely. It would be easy to call it the sword and the shield, except here the shield is shielding the client, and the sword is being wielded by an attorney who had an equal obligation.
Is the client affected by this at all?
Not at all. Not at all. The money comes solely from the attorney, from the attorney who brought in Mr. Mannheimer because of his experience. Their agreement is clear. There's no problem with that. But I think the appellate division spoke to that and spoke to the fact that Ms. Menkes cannot use the disciplinary rule to remove Mr. Mannheimer's estate from the fee she agreed to pay it.
And does it make a difference that she herself was also in violation of the rule?
Well, I think it does. I think it does very much so. I'm sorry, I thought I made that clear. That's the sword and, once removed shield, shield argument. I mean, there are things in Ms. Menkes' brief which are quite strange, and one of which is that she didn't have any idea that it was her
Why
obligation
should
to
it
do
fall
that.
harder on her than on your client?
Well, it
Is it a violation of public policy? Why should your client get the benefit?
Well, it doesn't. And the reason is because Ms. Menkes prohibited my client from speaking to her client for various obvious reasons. Jeffrey Mannheimer was a very well-known attorney, very highly thought of in the bar, and she was worried that Mr. Mannheimer was going to steal her client. So she excised him from that relationship. So
Is
he
that
didn't
an
have the
excuse
ability.
not to comply with the rules?
Well, the agreement says that he's not allowed to contact the client. These clients had been Ms. Menkes' clients for over 3 years. So I don't think that it weighs evenly on both sides. And surely, for the purposes of what's before this court, which is the
You're
fee
saying between the
dispute-
two, she acted more egregiously.
Yes, but I don't really think that is necessary here, because I agree with you, but or with your suggestion anyway.
Thank you, Mr. Breakstone.
Thank you.
Mr. Horn?
Thank you, Your Honor. I think briefly, I'd like to touch upon the preservation issue that was raised by Mr. Shute, and I would respectfully refer the court to page 18 of that very memo of law, which I referred to in my brief, and you'll see that the argument there, broadly stated, agreed, is that there was no definitive deadline, May 20th. It had to be settled that day. That's the end of it. If it doesn't settle that day, binding, then he's entitled to the 40%.
Well,
At the oral argument,
Counsel, couldn't Ms. Menkes have inserted some kind of language in the contract? She was not without the ability to insert language to say the mediation process or the mediation whenever it ended, or some other language that would suggest it was beyond May 20th.
there's no question that this agreement could have been better drafted, for sure. The way that the language is, however, under the case law which I've cited, that temporal reference merely describes the mediation. Mr. Shute admitted during his presentation that if you remove that language, it doesn't change the meaning of the sentence. And that's the very definition, by the way, of the distinction between a clause of description and a clause of limitation under Gravitt, NACS, and Massachusetts Mutual.
Going back to something that Judge Stein asked earlier, how do you know when the mediation ends?
Well, I think
Judge
that
Herkin-Torres only billed for 5 hours. Does that mean the mediation ended at the end of that billing period?
certainly not, Your Honor. I mean,
Why
we have
not?
all this information in front of us as to what exactly transpired thereafter. I read from you the Boole affirmation, which is that the parties broke, and by the way, the The representation in the appellant's brief was not that the parties broke because of a cold. It was because, and I refer you to page 17 of the appellant's brief, because they had reached the limit of their authority to settle, the excess carrier. That's at page 17, referring to page 912 in the record. That's why they broke. That's why Mr. Boole affirms, the only objective independent person that was there that's not here today, and he says it was fully contemplated that the mediator was going to reach out to the excess carriers to get more money, hopefully. That's precisely what he did. And I refer you to page 18 in my appellant's brief, which talks exactly about what Judge Herkin-Torres did.
Only if the mediator could not have gotten more money from the excess carrier would the mediation have ended?
Well, I don't think it needs to be that definitive. I think, we're talking in hypotheticals, and the thing that I keep coming back to is that the mediator settled the case. The mediator is the one who got the number from the excess carrier, related it to the plaintiff's counsel, received the acceptance from the plaintiff's counsel, and brought the parties together.
What if they agreed on the number, but they weren't able to agree on the structure?
If it falls apart, then it falls apart. But the fact of the matter is—
But the mediator had no involvement in negotiating the structure.
That shows you just how ancillary these things that are now elevated to—
Well, that's because it turned out it resolved. If it hadn't resolved, we might be in a different—
We might very well be in a different
But then would you be
position.
saying the mediator produced a settlement?
The mediator would have brought the parties together in furtherance of a settlement. Whether it was ultimately signed, sealed, and delivered, obviously under that hypothetical is not the case. One last point that I would like to leave Your Honor with, again on the preservation point. Page 52 in the record, the exact argument that's based upon Gravitt and NACS and Massachusetts Mutual about the dispositive import of commas appears during the argument, presented to the trial court, and was addressed by the trial court in her decision. It was presented to the appellate division in the briefing. It was addressed in the majority opinion. It was addressed in the dissenting opinion. The issue is clearly preserved. Thank you, Your Honors.
Thank you, counsel.